it's over. All right? I hope you get that. We are halfway through. No? This is already topic 5. A partner, being part of a partnership, has certain property rights, which have 3 dimensions. No? There are 3 dimensions to the property rights of a partner. The first one is what we call the rights of a partner in specific partnership property. Now, of course, this right contemplates or covers only tangible property. Tangible property, property nating nakikita at nahawakan. Sasakyan, makinarya, papeles, gamit, appliances. Now, of course, the partners have equal rights to possess partnership property for partnership purposes. Remember when we started out at topic 1 in nitong midterms, no? Earlier in this this video aggregate. Kanina sinabi natin, no? Yun sa ating guidelines on or rules on what exactly constitutes a partnership. Sinabi natin na co-ownership by itself will not establish the existence of a partnership contract. Kasi there has to be something else, diba? There has to be a business endeavor. A business endeavor, the intention of which is to gain profit. On the other side of that spectrum is this. In the context of a partnership, the partners own the partnership property in common. They have equal rights to possess partnership property because they are similar to co-owners. But take note that they are sort of co-owners for a limited purpose only. Kasi when we talk about co-ownership in general, basically, they can exercise all rights of ownership. Diba? Pwede mong gamitin yung gamit, yung tinatawag nating jus utendi, the right to use. You also have jus fruendi. Of course, if you have the right to use the thing and you own the thing, and if the thing bears fruits, then of course, you have a right to the fruits. You can dispose of the thing. Kasi sa'yo nga, pwede mong ibenta. Jus dispodendi. And of course, the not very often raised, no, or discussed, yung tinatawag nating jus abutendi. You have the right to abuse the thing. Kung meron kang smartphone, at meron kang kausap, late night, kahit na alam natin na kapag you are on a phone call or a messenger call or what have you, for extended periods of time, it has a negative effect on the battery. The battery might overheat. And especially if you talk to somebody on your smartphone nang naka-charge yung phone, it also has certain risks that come with it. But it's your phone and it's your charger. And yun nga, it's your life. You have every right as the property owner to abuse the property. You have every right to abuse the thing. So that's jus abutendi. So normally, co-ownership contemplates all of those different rights that come as a bundle with ownership. However, dito, when we talk about partnership, limited yan. The partners, sure, they have equal rights to possess the property belonging to the partnership, but only for partnership purposes. Okay? Kung yung sasakyan kailangan ginagamit, no? Kinontribute yung sasakyan sa partnership property sa common fund para mag-deliver ng sabihin natin, ang business ng partnership baboyan. Kung yung sasakyan pang deliver ng mga baboy, ng mga biik, sa ganun mo lang siya gagamitin. Now, of course, this is real life. And sometimes, yung gamit na para sa trabaho, nagagamit para sa leisure, nagagamit para sa ibang bagay. Like for example, the partnership owns a resort business. Sabihin natin somewhere in Laguna where there are a lot of hot springs. Now, ngayon, itong si partner A, gusto niya sanang magpaalam sa kanyang mga co-partners Na pwede ko bang mahiram? Pwede ba nating isara yung resort for a day? Kasi magga-grand family reunion kami. Kasi 'di ba alert level 1 na sa in most of the cities, municipalities and provinces here in the Philippines. Save a few exceptions, 'di ba? Most of the places here in our country alert level 1 na. At dahil doon, napaka-lax na ng travel restrictions. So this will be the first time, sabi ni partner A kay partners B and C. Sabi ni A, ito yung first time in a very long while, in 2 years, na magkikita-kita kami ng buong angka namin. So kung okay lang sa inyo, gusto kong gamitin sana yung resort. Kahit na isara lang natin, isang araw lang naman. Isang araw lang naman tayo walang kita. Normally, malakas naman ang kita natin. So evidently, that's not for partnership purposes. Malinaw na ang purpose niya is gusto niyang gamitin yung partnership property, i.e. the resort, for a private matter. Gusto niyang gamitin para sa kanilang grand family reunion. Pwede ba yun? The answer, class, is of course, yes, pwede yun. But, you have to take note of the but, may pero na kasunod yan. The consent of the other partners is necessary. Kailangang pumayag ni partners B at C para magamit ni partner A yung partnership property, here in our example, the resort, for a private purpose. Now, of course, if a partner is excluded from possession, etc., of the partnership property, for example, no, for whatever reason, may hindi pinapagamit na property yung mga co-partners. Sabihin natin ito. Merong talyer business. So car repair shop, car wash, car tuning, car customization na business si partners A, B, C, and D. Ngayon, napapansin ni partner D na doon sa isa doon sa mga warehouses kung saan nila hinahouse yung mga car parts nila, ng mga iba nilang equipment, parang meron siyang nakitang isang sports car sa loob. Ngayon, itong sports car na to, hindi mawala-wala sa isip niya. Kasi this particular sports car, meron lang 5 ganitong kotse in existence. Ever. So naisip niya, nawiwindang siya. Hindi ba ako nakakain kanina? Kulang ba ako sa tulog? This is a very rare car na nakita ko sa sarili naming warehouse. Oh, of course, no, bilang na nasa warehouse nila yun, he has every reason to think na that's partnership property. I mean, office premises nila yun eh. Talyer nila yan. So, nandiyan yung sasakyan, that must be the property of the partnership. Sa atin yan. So, syempre, natuwa siya. Yung gulat niya, napalitan ng tuwa na, oh, mayroon pala tayong magandang kotse dyan, hindi nyo sinasabi sa akin. So, abote nga yung ngiti niya, pinuntahan niya si partners A, B, and C. So, sinabi niya, oh, hindi nyo naman sinasabi sa akin na mayroon tayong luxury car dyan sa likod. Ngayon, itong si A, B, at C, parang nakakita ng multo. Namutla sila nung narinig yun kay D. Evidently, they were trying to hide it pala. Sabi ni A, wala yun. Wag mo nang tignan yun doon. I-ignore mo na lang. So ngayon, nagkulat si D. Oh, bakit gano'n ang reaksyon nila? Ano bang meron? Hindi ba dapat, ano nga yan? Oh, may pagmalaki natin na meron tayong luxury car dyan. Hindi natin i-joyride, di ba? Pero nung naisip ni D, sa paglipas ng mga oras, napakasuspetyoso ng reaksyon ng mga co-partners niya. Why did they react that way? Questionable ba yung pag-acquire doon sa sasakyan? Ano ba yan? Pinapatago lang ba yan ng kung sinong kriminal? At bakit parang kabadong-kabado when I brought up the topic of that sports car? In that kind of situation, si partner D, he may ask for 2 things. Number 1, he may ask for an accounting. No? Or, he can have the partnership dissolved by the court. Again, we will be going into dissolution later on. As a general rule, and as opposed to what we have discussed earlier regarding assignment of right, diba? Sabi natin kanina, a partner can assign his or her right to the profits of the partnership. So whatever profits na mapupunta dito sa partner na to, pwedeng i-assign ni partner yan sa third person. However, a partner's right in partnership property cannot be assigned. Not assignable yan pursuant to Article 1811 of the New Civil Code. Except when all of the partners assign their rights in the same property. Kasi di ba, limited co-ownership. All of the partners own the partnership property in common for partnership purposes. So hindi pwede na i-assign ni partner mag-isa yung kanyang right over a particular partnership property kasi hindi lang naman siya ang may-ari niyan. Kailangan pa ng consent, ng conformity ng kanyang co-partners. And how is that conformity acquired? When the other partners themselves assign their respective rights over that same property. So everybody assigns their rights to a third person. Saka lang pwede. Now, of course, the right of a partner in specific partnership property is not subject to attachment or execution. Ibig sabihin, what do we mean by attachment or execution? Ibig sabihin, 'di ba? Remember what are the remedies through which a creditor may enforce payment of an obligation. Kung naalala pa ninyo, this is obligon, this should be basic for you. Number 1, specific performance. Presuming na may pambayad si debtor, di pagbayarin. Okay? Ngayon, walang pambayad. Anong gagawin? You pursue the properties, no? The properties of the debtor. Kukumpiskahin yung properties at ibebenta. Okay? Ngayon, kung kulang pa rin at hindi pa rin kaya, you go against the debtors of your debtor, no? Action subrogatoria, kung naalala pa ninyo, di ba? Action subrogatoria, you step into the shoes of your debtor and then you go against those persons who owe your debtor. Ikaw yung maniningil at yung kung ano man ang masingil mo, gagawin nating pambayad sa utang ni debtor sa'yo. And finally, when all else fails, action, Pauliana. The nullification of contracts entered into by the debtor in fraud of creditors. So, number 2 doon, di ba? Exhaustion of the debtor's property. Ang ibig sabihin, when we say that the right of a partner in specific partnership property is not subject to attachment or execution, assuming that a partner, meron siyang sariling pagkakautang sa isang third person, ay hindi pwede, no? Sabihin natin, hindi nag-succeed ang specific performance. Kulang ang assets ni partner para bayaran yung utang. Kulang yung pera niya. Pero meron siyang properties, di ba? So yung properties pwedeng kumpiskahin at ibenta. Kasama ba sa pwedeng kumpiskahin yung right, no, ni partner sa partnership property, sa specific partnership property? Can partnership property be confiscated in order to pay the debt of the partner? The answer, of course, is no. Partnership property cannot be confiscated for the payment of a loan by any partner in their individual or personal capacity against some other person. Of course, ang exception is if the claim is not against any individual partner. But if the claim is against the partnership, kung mismong si partnership ang may pagkakautang, in that case, hindi immune ang partnership property to attachment and execution. All right? Now, of course, finally, the right of a partner in specific partnership property is not subject to legal support. You see, under our family code, the spouse and the children are entitled to legal support. The spouses, ang mag-asawa ay may obligasyon na suportahan ng isa't isa. The implication, of course, is if one of the spouses does not have work, obligasyon ng asawang may trabaho na buhayin ng kanyang esposo o esposa. Of course, every parent has the obligation to support their children. Support being, to provide for their needs para sa kanilang ikabubuhay, para sa kanilang edukasyon, for their health and development. That is all provided under the family code. Ngayon, if the person who is obliged to give support fails or refuses to provide said support, an action in court may be filed to compel that person. Kadalasan na pinafile yan against yung mga estranged o mga absentee fathers, na ayaw bigyan ng sustento yung kanilang asawa and or anak. And of course, the remedy would be that the court decrees or compels the absentee spouse/father to provide the needed support. For that purpose, minsan, the court confiscates properties of the absentee father or the person yun nga obliged to give support. Ibebenta yon at yung proceeds nun ibibigay doon sa mga entitled to support. In the same way that a partner's rights in specific partnership property cannot be subjected to attachment and execution, ganun din sa support. Partnership property cannot be confiscated for the furnishing of legal support to a partner's spouse and or children. That's under Article 1811 of the New Civil Code. Now, of course, the second aspect of a partner's property rights is yung tinatawag nating a partner's interest in the partnership. Needless to say, a partner's interest in the partnership is his or her share in the profits and the surplus. Malamang sa malamang, di ba? Yun lang naman ang interest ng bawat partner. Yung kanyang kita. Okay, yung share niya sa kita ng partnership. It's as simple as that, provided under Article 1812 of the Code. Now, a partner, like what we said earlier, a partner can of course convey or assign his or her interest in the partnership. A partner can do so to any of his or her co-partners without the need to secure the consent of everybody in the partnership. Kasi hindi naman lumalabas, hindi naman lumalabas dun sa partnership, dun lang sa loob. However, can a partner do so to a third person or a non-partner? Kagaya ng diniscuss natin kanina, of course, the answer is yes. Whether the other partners consent or not. Yung tinatawag nating sub-partnership. Of course, yung assignee o sub-partner is not elevated to the level of a partner. It is only when all of the other partners consent that the sub-partner can evolve or level up, so to speak, into partner status and is, as a result, admitted to the ranks of the partnership. Now, of course, there is an exception to this rule. If the partners stipulate to the contrary, in other words, if the partners make it a requirement that everybody in the partnership consents before any assignment, etc., can be made, then of course, obligatory force of contracts again, freedom to stipulate again. The stipulation is not contrary to law and therefore, the partners should honor that. Now, another thing. The assignment of interest does not enable the assignee to do any of these things. The assignee or sub-partner cannot interfere in the management of the partnership. The assignment also will not enable the sub-partner to require any information or account of the partnership. And lastly, it does not enable the assignee to inspect any of the partnership books. Bakit? Why do you think is the reason for that? The reason is simple. Like what we said a while ago, when a partner assigns his or her right to a sub-partner, yung sub-partner hindi nagiging partner. And therefore, he or she referring to the sub-partner, cannot exercise any of the prerogatives that come with being such, with being a partner. Hindi niya pwedeng i-demand na basahin yung mga books of account ng partnership. Hindi siya pwedeng magpresenta, no? Or magbida-bida sa kung paano patatakbuhin ng partnership. That's out of the sub-partners league. Like what we said, di ba? Why is there such a prohibition? We double back to the core principle of delectus personae, di ba? Trust and confidence. Hindi pwedeng magpapasok ng total stranger within the ranks of the partnership unless and until all of the partners agree. Because this is a business endeavor, class. You have to always keep that in mind. And what is the point of doing business when your supposed business partner is not someone who you can trust? Kaya hindi automatically nagiging partner ang isang assignee. Just a sub-partner, a mere sub-partner entitled to the profits that the assignor, that the assigning partner are entitled to or is entitled to by virtue of the partnership relation. There has to be a positive act on the part of the other partners, of all the other partners, in order to elevate the status of the sub-partner into one of a full partner and part of the partnership entity itself. Di ba? Hanggang profit lang. Ang sub-partner, ang assignee, hanggang profits lang ang pwede nilang makuha. And of course, in case of fraudulent management, which would inevitably affect the transfer of profits, the assignee can ask for dissolution. Pero hanggang doon lang yun. Hindi siya pwedeng mag-participate doon sa nitty-gritty ng pagpapatakbo ng day-to-day business of the partnership. An assignee, a sub-partner, can only do so much. Which brings us to the right of a partner, as in an out-and-out partner talaga, not a sub-partner, to participate in the management of the partnership business. Managing partner, class, ang tawag natin sa partner who has been appointed manager in the Articles of Partnership. Basically, the Articles of Partnership is a document submitted to the SEC, the Securities and Exchange Commission, outlining the roles of the different partners, ano ba yung kanilang ginagawa, what their contributions are to the partnership, the particulars of the business, etc., in order for the SEC to be able to more competently regulate, no? To exercise its regulatory powers over all partnerships and over all other business entities or vehicles here in the Philippines. So ang managing partner can execute or may execute all acts of administration. Kailangan bang may concurrence or agreement lagi ang lahat ng mga partners every time the managing partner does his or her function or does his or her job? No. Kasi kung kinakailangan laging merong 100% conformity ang managing partner, wala siyang magagawa. Imagine every decision point that a managing partner would reach, kailangan mo magpatawag ng meeting. Kailangan mong i-explain yung matter at hand, tapos kinakailangang bumoto. Tapos hindi makakagalaw unless and until all of the partners agree. The partnership will accomplish nothing. And therefore, the managing partner is allowed by the law to execute all acts of administration despite the opposition of his or her partners. Basically, the law gives ample discretion, ample elbow room for the managing partner to manage the partnership. Of course, there is an exception to this rule. If the managing partner has been proven to have acted in bad faith. So kung merong lokohang naganap, kung merong deliberate intent to mislead or to fool the other partners, then of course the other partners can prevail over the actions, over the unlawful actions of the managing partner. Now, of course, the managing partner's power is irrevocable without just or lawful cause. In other words, medyo confusing kasi yung wording niya, no? Admittedly. Kasi hindi naman perfect ang Code Commission. Basically, ang ibig sabihin nito, the power of the managing partner can only be revoked if there is just or lawful cause to revoke. Hindi siya pwedeng ma-revoke ng walang dahilan. Basically, class, that is all that it means. And what is needed? What is needed in order to revoke such an action on the part of the managing partner? There has to be a vote of the partners representing the controlling interest. So for example, kung nasusubaybayan ninyo ang Twitter, you would have learned of how Elon Musk of Tesla and the SpaceX and an insufferable meme lord, no, na madalas magkalat sa social media, but hey, genius, no? You have to admire that level of mental acuity. But my point is that Elon Musk has been able to buy a majority of the stocks/shares of Twitter. And therefore, siya yung mayroong controlling interest. So, translate that to partnership. So long as the vote of the partners representing the controlling interest is secured, the acts, no, of a managing partner can be revoked. Although, of course, ultimately, there has to be just or lawful cause for revocation. Kailangan may rason. Meron bang overreach? Meron bang pagkakamali sa decision-making ng managing partner? Was the managing partner wrongly informed? Mga tipong ganong bagay. So, in order to revoke the power of a managing partner, there has to be two requisites, two elements. Number one, just or lawful cause for revocation. And number two, the vote of the partners representing the controlling interest in the partnership. A power granted after the partnership has been constituted, of course, may be revoked at any time. Kasi like partners, no? Like partners na pwedeng pumasok sa partnership after the partnership has been constituted. Like in many accounting and law offices. Sometimes, the partners agree to vest new powers to the managing partner after the partnership was constituted. Think of it parang mga amended contract, mga amendments sa kontrata na later on may idadagdag na panibagong mga clause, no, to improve the agreement. Ganon din sa partnership. Sometimes provisions or powers or rights even are granted after the partnership has been constituted. So may amendments to the partnership contract. If that power has been granted in this way, after the partnership has been constituted, it may be revoked at any time. So if at any time, ibig sabihin, hindi na niya kinakailangang dumaan dun sa proseso na dinescribe natin kanina na mayroong dalawang requisites. Yung may just or lawful cause at yung vote nung controlling shares, no, doon sa partnership. Now, what if, no? So far kasi, what we have contemplated ay yung situation where we have only one managing partner. Now, sometimes there are instances where a partnership has two or more managing partners. Sometimes, itong managing partners na to, outlined specifically yung kanilang mga duties, kanilang responsibilities. No? Itong managing partner na to, ito lang yung kanyang mga dapat gawin. On the other hand, this other managing partner, ito lang yung extent ng kanyang responsibilities. Now, what if, no? What if walang ganong specification? Or, no, there is no stipulation that one managing partner cannot act without the consent of the other managing partners. Kumbaga, there is no stipulation that the managing partners should act as a team na kinakailangang mayroong concurrence sa kanilang lahat before performing an official action. In those situations, each one of the managing partners may separately execute all acts of administration. Kanya-kanya. Hindi na kinakailangang maghintay sa desisyon ng ibang managing partners. Every one of them can perform the needed actions immediately. Now, in case later on, nalaman ng isang managing partner, binenta mo yung isa sa mga sasakyan natin. Now, if any of the managing partners shall oppose the acts of the others, the decision of the majority shall prevail. In other words, once one of the managing partners opposes the actions or action of his or her fellow managing partner, kinakailangang i-put into a vote amongst the managing partners. Kinakailangan nilang magbotohan. Was the action opposed right? They have to vote for that. They have to vote on that. And the decision of the majority shall prevail. Now, what if there was a tie? Then, papasok yung partners owning the controlling interest. Sa kanila ibabato yung tanong. And then, they shall decide on the propriety or rather on whether the actions contested were proper or were right. This is outlined under Article 1801 of the new Civil Code. Now, if it was stipulated that none of the managing partners shall act without the consent of the others, ito yung sinabi ko kanina na may nakalagay doon sa partnership agreement na we have multiple managing partners at hindi sila pwedeng gumalaw ng walang agreement nilang lahat. Then, of course, in such a situation, the concurrence of all managing partners shall be necessary for the validity of the acts. Ngayon, syempre, pwedeng mangyari na, the reason why we tried to put the matter into a vote, but one of the managing partners was not able to vote kasi, for example, indisposed siya, may sakit, ganyan, kaya hindi siya nakaboto. The absence of disability of any one of them cannot be alleged. There has to be proof. There has to be proof. Unless there is imminent danger of grave or irreparable injury to the partnership. So basically, ano ang ibig sabihin ni Article 1802 of the Code? Simple lang naman. Number one, if the partnership contract dictates that all of the managing partners can only act if they all agree, then they have to agree. Otherwise, they cannot act. Now, of course, sometimes, sasabihin ng managing partner na nag-isip na let us do this despite the requirement na kailangan may concurrence ng lahat, tas tatanungin siya ng ibang partners, bakit ginagawa mo na yan? Hindi ba kinakailangan ninyong bumoto? Sasabihin ng managing partner na yung isang partner kasi may sakit, tapos yung isang partner abroad. Of course, in that situation, they cannot vote, di ba? Hindi yun pwede basta-basta i-allege. It has to be proven. Kung may sakit, kailangan ng medical certificate. It has to be proven. Kung abroad, kailangan may proof na nasa ibang bansa nga talaga. Hindi pwedeng basta-basta mere say-so lang nung managing partner. Unless, of course, yung urgency ng situation. There is imminent danger of grave or irreparable injury to the partnership. For example, the judgment call was made by one of the managing partners kasi wala nang pera para bumili ng sabihin natin restaurant business, wala nang pera para makabili nung karne na gagamitin for the coming 2 weeks, kailangang emergency, magbenta tayo ng kung anong meron dyan. So, naisipan na ibenta yung isa sa mga sasakyan. Kung hindi nga naman makakabili ng karne, anong iluluto nila? Diba? It would result basically in the death of the business. So, in that kind of situation, there is an imminent danger of grave or irreparable injury to the partnership, which would necessitate a judgment call. Hindi na makakapaghintay na bumoto pa yung ibang partners. Kailangan natin tong gawin in order to keep the partnership afloat, in order to keep the partnership alive. So in that situation, pwedeng i-override ng managing partner yung requirement that the concurrence of all of the managing partners should be needed as a prerequisite. Now, when the manner of management of the partnership has not been agreed upon, so hindi malinaw, hindi nakalagay na mayroong managing partners, ito ang rules na mag-govern. All of the partners shall be considered agents of the partnership. So basically, the general rule here. And whatever any one of them does alone shall bind the partnership. Of course, without prejudice to Article 1801. Na if any of the partners shall oppose the acts of the others who made the action, then the matter shall be put to a vote, and it is the majority which should prevail. Okay? Next, none of the partners may, without the consent of the others, make any important alteration in the immovable property of the partnership, even if the alteration is useful to it. Okay? Ano ang ibig sabihin nito? Restaurant, no? Noong time na bumababa yung alert level from ECQ to MECQ, pinayagan ng IATF ang alfresco dining. Ngayon, itong iba sa mga partners, naisip nila na, wala tayong space sa labas para sa alfresco. So ang gawin natin, tibagin natin yung kalahati ng ating restaurant space. Tapos puwersahan nating gawing alfresco yung kalahati. So basically, tinanggalan ng kisame, tinanggalan ng bubong, yung dingding tinibag. Leaving only half of the restaurant property intact, tapos gagawing alfresco yung naiwan. Ang hindi na take into account nito mga partners na nagmagaling, na ginawa nilang alfresco yung kalahati ng restaurant, bababa lalo yung alert level down to alert level 1, which now allows indoor dining. Ngayon, no? Ano ang makikita natin dito sa senaryo na to? The partners should have asked for consent from the others because the alteration here is an important alteration. Kahit na allegedly useful siya kasi paano tayo makakapag-compete dun sa mga ibang restaurant wala tayong alfresco space. So let's make an alfresco space. It's a substantial alteration to the partnership property. Akalain mo titibagin mo yung kalahati ng building just to make an alfresco space. It's not something that can be done offhandedly and without consulting all of the other partners. At the very least, dapat informed sila in order for everybody to be able to talk about it. Now, of course, no, what does this imply? At all costs, in all situations, there has to be at least a meeting between or among all of the partners. Ngayon, kung despite the meeting, ayaw pa rin ng ibang partners na let's not push through with that. If the refusal of consent is manifestly prejudicial to the interest of the partnership. So basically, naniniwala talaga yung mga partners na no, we have to do this. Kahit na the other partners refuse to. They have no choice but to go to court. They have to file a case in court. At doon sa korte pag-uusapan yung matter. With of course the intervention of the judge.